Happy dance. The Supreme Court has just struck down the New York concealed carry gun law in a 6-3 decision. And in this video, I'm telling you why this is a big deal. But before I break this decision down and what it means for gun owners like us, quick reminder, we have a gun giveaway going on right now. You can become a gun owner. It's absolutely free and it ends really soon. So click the link in the description down below to reveal which brand new gun you could win. As the third major ruling in a gun case since the Constitution was written, the Supreme Court, in a 6-3 decision, struck down a 100-year-old law in New York. The law, known as the May Issue Law, stipulates that an applicant must pass basic requirements and that the issuing authority, county sheriff, police department, whatever, is allowed to use their own discretion in either issuing or denying the permit. Basically, it's much harder to obtain a concealed carry permit in states that are may issue than states that are shall issue. I could say that liberal politicians are up in arms, but they hate guns. So, instead, I'm just going to say they're crying loudly about how this expansion of freedom will lead to increased crime. Let me point out that this is not an expansion of gun rights. This is returning gun rights that were previously infringed upon. So, the predictable refrain that there will be blood in the streets is being shouted once again, even though it has never come to pass. New York City Mayor Eric Adams said, "We cannot allow New York to become the Wild West." Guess what, Mayor Adams? Your city already is the Wild West. New York has some of the toughest gun laws in the nation and still suffers with violent crime and blood in the street. But now, good people will have the chance to fight back. This ruling will allow ordinary citizens of New York to get permits that are currently reserved for only the rich, the famous, or the well-connected. Until now, self-defense in New York City has been only an exclusive club. Let me give you a little background on the law that was just struck down. To receive an unrestricted license to carry a concealed firearm outside the home in New York, a person must have shown proper cause. This must be interpreted as a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. If a person does not have what New York deems a special need for self-protection, he or she can be denied a permit. Robert Nash and Brandon Koch each applied for a permit to carry for self-defense, and each were denied for these reasons. These men took that decision all the way to the Supreme Court, stating that the May Issue Law violates their Second Amendment right. Fortunately for responsibly armed Americans, the Supreme Court ruled that it did indeed violate the Constitution. So let's talk about what this Supreme Court ruling means for the other May Issue states. There are currently 9 states that have this May Issue clause in their concealed carry permitting process: California, Connecticut, Delaware, Hawaii, Maryland, Massachusetts, New Jersey, New York, and Rhode Island, but those are just for the permits issued by the Attorney General's office. The decision by the Supreme Court in New York State Rifle and Pistol Association versus Bruin will set the standard on how other states can regulate citizens choosing to carry concealed outside the home. It will no longer be at the discretion of the issuing authority. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms in public. That's a direct quote from Justice Clarence Thomas. He wrote that for the Supreme Court. However, the court's decision will not impact a state's right to impose licensing requirements to obtain a concealed carry permit. This means that each state can now set its own specific requirements, such as training, age, background checks, etc., to qualify for a concealed carry permit. Although the decision will then force the state to issue the permit if the applicant meets all of those requirements. But most importantly, what the ruling really does is right the historic wrong of racially motivated gun control efforts that created a permitting process designed to prevent certain groups from owning or carrying guns. President Biden said today he was disappointed and claimed that states have for centuries controlled who could carry guns. He's wrong about that. The truth about gun control is that it was racially motivated. The first real efforts at gun control sprang up during Reconstruction. Following the Civil War, Southern Democrats were afraid that newly freed slaves would arm themselves. As a result, the lawmakers began instituting laws requiring that permits to carry guns be issued by local sheriffs. Back then, all the sheriffs were white and would, of course, never issue a permit to a person of color, even if that person could afford to pay the fee. So Thursday's ruling strikes at the heart of racist gun control. The idea that a government agency can make you prove that you deserve to be allowed to defend yourself. The Second Amendment is for everyone. This ruling wipes away more than 150 years of racially motivated government control over the right of the people to keep and bear arms. No government agent should decide if your life is worth protecting. We always knew that May issue laws were unconstitutional, arbitrary, and unequally applied. Now the Supreme Court has made it clear that the freedoms protected by the Bill of Rights are to be enjoyed by all citizens, not just those with political clout to buy the right to carry a gun. So what can you do next? The answer to that is to never, under any circumstances, let up. There are no days off. There are no cheat days or weekends or any other half measures in the fight for liberty. Those who would seek to disenfranchise you of your fundamental human right to effective self-defense never rest, and we can't rest either. Continue contacting your representatives at all levels, preferably by phone and by mail. Emails are easy for interns to delete and for the intended recipient to never even know existed. Phone calls and physical snail mail are not. We must use this moment to continue driving home a single message. Gun control is un-American, and gun control is a political loser for any politician who is even thinking about throwing his or her weight behind a new gun law anywhere but the most rabid of anti-gun corners of the American political scene. Want to know the 3 biggest mistakes when carrying a handgun? Then click on the video next to me to reveal all 3 mistakes. Mistake number 2 may shock you. Everybody has their own cardinal rules for what they're going to do when they're carrying a gun, but right now I'm going to give you 3 things that you must never do